So next question is on interstate council. So give an account of the composition, mandate, and functioning of the interstate council in India. So the approach is, give the constitutional provisions first, introduce it with the article, and then the composition of it, and then functioning. So Article 263 of the Constitution, as you know, provides for the establishment of interstate council by the president. So mention the bodies here to facilitate coordination of policies and their implementation between the union and the states. So interstate council basically for the coordination, a key aspect of federalism we can say, in the pursuance of the provisions under Article 263, and after the recommendation of Sarkari Commission, ISC was created as a constitutional body by presidential order in 1930. So, bring about the role of Sarkari Commission also, though it was provided in Constitution, it was created later. And then the composition of Interstate Commission, the ISC was reconstituted in 2019. That's why the question has been asked, a part of current affairs. It now includes the PM as a chairman, very key point, chief ministers of all the states, chief ministers and administrators of the union territories not having the legislative assembly, administrators of union territories who were not having the legislative assembly, and then six cabinet ministers as per the norm recommended by the prime minister. So there are also 10 union ministers as permanent invitees. So the mandate of the mandate, duties, and functioning of ISC is that ISC is a recommendatory body, just like the NHRC, with the following duties. So next question is about the functioning. So mandate, composition we have discussed. Now coming to the mandate, functioning and mandate and functioning. So investigating and discussing such subject in which all of the states or the union and one or more of the states have common interest. So discussing those subjects which one or more states have a common interest. It may be something like an interstate water sharing, a boundary dispute, such thing, and making recommendation upon any subject, in particular recommendations for the better coordination of policy and actions with respect to that subject. So they can make recommendation, particular recommendation for better coordination. Maybe anything, border sharing. It may be trade issue, interstate trade. It may be interstate boundary sharing, water sharing, river water sharing. So deliberating upon such other matters of general interest to the state. So they must deliberate upon such matter which is about general interest to the states and may be referred to by the chairman to the council. The council has dedicated secretariat, as we know, it helps in functioning. To carry out its functions, it has a dedicated secretariat. The standing committee on the interstate council has been constituted for continuous consultation and processing of matters for the consideration of the council. So currently, the standing committee comprises of Union Home Minister. So this is a key fact. The standing committee comprises of Union Home Minister as the chairperson, and four union ministers of cabinet rank, and eight chief ministers of state as members nominated by the chairman of the interstate council. So this is about the general council of the secretariat. And then the standing committee, what are the functions of the standing committee? As we discussed, standing committee would have a continuous consultation and process, it will have continuous consultation, it will have continuous consultation and process matters for consideration of the council. So there is aspect of consultation involved, because there are multi-state issues involved, to process all matters pertaining to center-state relations before they are taken up for consideration of the interstate council. So before they go to interstate council, there is a standing committee. So this will take up the issues, monitor the implementation of decision. Also, if there is any decisions taken, it will monitor those decisions taken on the recommendations of the council and consider any other matter. So consider any other matter referred to it by the chairman. It's a general thing. The standing committee may also invite experts. So here comes the role of expert opinion and persons eminent in the specific fields to have the benefit of their views while deliberating upon the subject. The council was slated to meet thrice. It was slated to meet thrice a year, given its important functions in promoting cooperation, coordination, harmonization of its policies. It was slated to meet thrice a year. It has a pivotal function in facilitating the trust between the center and states. However, the functioning of the council has been far from satisfactory. This is the disappointing fact that has been far from satisfactory. The meeting of the council have been quite infrequent, given the need for strengthening and understanding the cooperation between center and states, and also among states. So the council is an appropriate body that needs to be given importance. So this is the concluding line, which says that given the need for strengthening and understanding cooperation, between center and states, and also among states, the council is an important, appropriate body that needs to be given importance, right? So this is a important one with respect to interstate council. First of all, talk about the composition, constitutional basis, circular commission, the composition broadly, and then mandate of the function, and also talk about quickly about the standing committee, its role, and its effectiveness in terms of functioning. So next question is about the Lok Sabha and Rajya Sabha power comparison. So see the question. Although the Indian Constitution gives Rajya Sabha some special powers, okay, it is given some special powers we are acknowledging because of its role in federalism. Yet on most matters, Lok Sabha exercises supreme power. Now we also know the logic why Lok Sabha has been given supreme power, because they are the ones who are directly elected. They perform the role of representation in the democracy. So that is why they've also been given some more powers, especially with respect to money bill and such things. So we'll discuss. So briefly, we try to briefly outline the structure of the parliament in the introduction, because it is talking about both Lok Sabha and Rajya Sabha. So give a broad overview of parliament. Discuss how Indian constitution gives some special powers to Rajya Sabha. This is the first part of the question, and then make a comparison of the powers of Rajya Sabha and Lok Sabha, and then establish how the in some areas the powers are common. Establish how Lok Sabha exercises supreme power in most cases. In the concluding part, that's about the question. So, Indian Parliament, as you know, consists of two houses, that is Lok Sabha and Rajya Sabha. The upper house, the Rajya Sabha is an indirectly elected body. This we discussed, and represents the state. So here, Rajya Sabha plays a role of federalism, representing the state. So, due to its federal character, it has been given two exclusive powers. So because federal thing, it has been given two exclusive powers that are not enjoyed by Lok Sabha. So these two powers becomes important to remember always. So it can authorize the parliament to make a law on a subject enumerated in the state list. So if there is anything law to be done on the state list, Rajya Sabha can authorize the parliament to make such a law, and then it can authorize the parliament to create a new all India service, a common to both center and the state. So this is the role of Rajya Sabha, where a new all India service it can recommend, because all India service, if the Lok Sabha can do, they can always create one more all India service, but this has to be done with the consensus of states. That is why all India service logic goes for Rajya Sabha, and state list, as we know, states have the prime authority, so that is why it has been given to Lok Sabha. So 249 and 312, as we know, all India judicial service was done via this mechanism in 42nd Constitutional Amendment Act. However, Rajya Sabha has an unequal status. As we see, Rajya Sabha has an unequal status with Lok Sabha, seen on most matters, except these two. As we see, Lok Sabha has supreme power. First and the most important thing is a money bill. So a money bill can be introduced only in Lok Sabha. So it starts from here. It can be introduced only in Lok Sabha and not in Rajya Sabha. Rajya Sabha cannot amend or reject the money bill. It should return the bill to the Lok Sabha within 14 days, either with the recommendation or without the recommendation. And then the Lok Sabha can either accept or reject. So Lok Sabha can either accept or reject all or any of the recommendations of the no. The Lok Sabha can either accept or reject all or any of the recommendations of the Rajya Sabha. So it's left to the discretion of Lok Sabha whether they can accept the recommendations. In both the cases, the money bill is deemed to have been passed by both the houses. So they're almost negligible role of Rajya Sabha in this context. And then if you see the second focus, it is about the financial bill. First is about money bill, next about financial bill. A financial bill, not containing solely the matters of article 110, can also be introduced only in Lok Sabha. So this is also one important fact, where a financial bill not containing solely the matters of article 110, this also has to be introduced only in the Lok Sabha and not in Rajya Sabha. But with regard to the passage, then no, there's a parity. Only with respect to introduction, here we have upper hand for Lok Sabha. And then coming to joint sitting, the Speaker of the Lok Sabha presides over the joint sitting. So this we all know, Speaker is from the Lok Sabha. So again, here in joint sitting, there's an upper hand for Lok Sabha because Speaker presides it. In terms of joint sitting, the Lok Sabha with greater number, as we know, prevails in the joint sitting, except when the combined strength of the ruling party in both the houses is less. So in all practical cases, this would be such that Lok Sabha would have upper hand in the joint sitting because of the sheer number. And then comes to budget. So budget, as we know, part of the financial bill or money bill, we can say, as Rajya Sabha can only discuss the budget. It can only discuss the budget, but it cannot, vote on demand for grants, which is an exclusive privilege of, uh, which is an exclusive privilege of Lok Sabha. So here again, budget. money matters is purely in the hands of Lok Sabha. And then coming to emergencies, now look at some of the unitary provisions, such as a resolution for discontinuation of national emergency. So if they have to discontinue national emergency, it can be passed only by the Lok Sabha and not by the Rajya Sabha. So here again, to discontinue emergency also, uh, Lok Sabha has an upper hand. And then coming to no confidence motion, the Lok Sabha cannot remove. Here again, the Rajya Sabha cannot remove the Council of Ministers. So, no confidence motion, Rajya Sabha cannot remove the Council of Ministers by passing no confidence motion, because no confidence motion can only be introduced in the Lok Sabha. This is because Council of Ministers is collectively responsible to the Lok Sabha. That is why no confidence motion is not allowed here. Rajya Sabha can only discuss and criticize the policies and activities of the government. So it cannot pass a no confidence motion. So these are the aspects in which Lok Sabha is having upper hand. This is money bill, this is financial bill with respect to introduction only. Talking about joint sitting of the both the houses, where the speaker presides. And then there's budget thing. So we can conclude club money bill, financial bill, and budget points together, and then move on to joint sitting. And then emergency was one federal thing. Um discontinuation only Lok Sabha, and a no confidence motion to remove them. So even though the Lok Sabha, even though Rajya Sabha has been given less powers as compared to Lok Sabha, it has key role. Okay, it has key role in preventing hasty decisions and ill-considered legislation by providing space for revision and thought. It also maintains the federal equilibrium, as we discussed in the earlier question, that it plays a key role in federal equilibrium. Here comes the role of judicial review, also comes the role of Rajya Sabha, such things. So even though Rajya Sabha has been given less powers as compared to Lok Sabha, it has a key role in preventing the hasty decisions. It has the senior leaders. It's considered and ill-considered legislation by thus providing space for revision and thought. So this is a key role for Rajya Sabha. It also maintains a federal equilibrium by protecting the interests of states against the undue interference by centers. So this overall perspective with respect to powers of Rajya Sabha, where it has upper hand in two aspects, that is the matters of state list and all India services, and then some matters where Lok Sabha is apparent, but in general there are other matters also where there are equal powers. For example, passage of all constitutional amendment bills, it must be separately passed and such things. Okay, so this is about the Lok Sabha special and Rajya Sabha also special powers. So moving on to the next question, it's about CAG, constitutional body. So this can be easily understood. The role of C. What is the role of CAG in important means area? Role of CAG as a constitutional body, and mention the constitutional provisions to ensure its independence. So these are the two dimensions: role as well as the constitutional provisions which give provide for independence of such constitutional bodies. So I read a brief introduction about CAG mentioning the articles, and then highlight the role in terms of auditing and accounting roles. Here there are two heads under which we can write auditing and accounting roles, and then give point about the independence ensured by the Constitution. So, Article 148 of the Indian Constitution provides for the office of CAG of India. He is appointed by the President. So, if you see, he is appointed by the President under as the head of the Indian Audit and Accounts Department. So again, fact. He also acts as watchdog. So, he acts as a watchdog to see the various authorities under the Constitution function in regard to financial matters in according with the Constitution and the laws of the Parliament. So, in a sense, he's a watchdog for these matters, especially financial matters. Now, coming to the role of CAG, as we've seen, there are two heads under which we can discuss: auditing role and accounting role. The first is the auditing role to audit. So, it will audit all receipts and audit all receipts and expenditures from the Consolidated Fund of India, as we know, the Article 266, and each state and each of the union territory having a legislative assembly. So, to audit all recipients into and expenditure from the Consolidated Fund of India and of each state and of each union territory having a legislative assembly, and to ascertain whether the money shown in the accounts as having been dispersed were no legally available for and applicable to the service and purpose for which they have been applied. So this is a auditing role where it will audit receipts as well as expenditure from the Consolidated Fund of India of each state and union territory having a legislative assembly, and to ascertain whether the money shown in the accounts they have been dispersed legally for and applicable to the service or purpose for which they have been applied. So whether it has gone for the right purpose, and then to audit all transactions of the union and states relating to the contingency fund and public accounts. So apart from the consolidated fund, they can also look into matters such as contingency fund and the public account. So to audit all trading, manufacturing, profit and loss accounts and balance sheets and other subsidiary accounts kept in any department of the union and the state. So again, apart from the two broad accounts, contingency, consolidated, public accounts, it can account all trading, manufacturing, profit and loss accounts, balance sheets kept in any department of the union or the state, and in each of the case, report on the expenditure, transactions, and accounts are so audited by him. So this is also one specific fact. Apart from those funds, they'll get into the specifics like these funds, and then to audit the receipts and expenditure of the bodies which are substantially financed by the union or state. So if there are other bodies who are funded by the state or center, so those bodies will also be audit the audit and the receipts and expenditure, and then to audit the accounts of government companies and the corporations. So government companies and corporations also, apart from the ones that are financed, so established by the law of the parliament in accordance with the provisions of the respective legislation, it will carry on the account. So this is the auditing role. Now coming to the accounting role, it's prescription of forms in which the accounts are to be kept in the union and state. So prescription of forms, how the account has to be maintained. So that it will specify submission of finance accounts and appropriation accounts to the president and governor, administrator of the union territory. This is done providing the necessary information to the union and state, the preparation of their budgets and annual financial statement. So they provide necessary information to the union and states in the preparation of their budgets or the annual financial statement. So this is about the accounting role. So how you have to keep your account, submission of the finance accounts and appropriation account to the president, governor, or administrator, and then providing necessary information to the United States in the preparation of the budget. So this is the overall accounting role. So auditing role and accounting role is there, and then now coming to the constitutional provisions to ensure its independence. So as we saw, it's a an important body which maintains the fiscal integrity in one sense we can say. So the constitution has made the following provisions to safeguard the independence of CAG. The first is a fixed tenure. So, talking about a fixed tenure, he holds the office for a fixed term of 6 years. So, he's holding office for a term of 6 years till he attains the age of 65. So, whichever is earlier, 6 years to 65. And then the criteria for removal is that he can be removed by the president only on two grounds. So, that is approved misbehavior or incapacity. As a judge of Supreme Court is removed. So, this is the a procedure under which he is removed, just like similar to a judge of Supreme Court, in accordance with the provisions mentioned in the Constitution. So again, two grounds, only on two grounds: proved misbehavior or incapacity. So as the judge of Supreme Court, this is the criteria for removal. Again, it's very stringent because no judge has been impeached till today. Likewise, you can find no CAG also can be done, and then fixed tenure we saw, and then eligibility for further appointment. So this has been curtailed. He's not eligible for further office either under the government of India or of any state after no his retirement. So this is also one key fact. And then entitlements. Coming to the entitlements, so no, these entitlements neither his salary nor his rights. So neither his salary nor his rights. So this is neither his salary nor his rights in respect of leave of absence, pension or age retirement can be altered. So it cannot be altered to his disadvantage after his appointment. So that is why he's mentioning the uh, entitlements cannot be varied. And then expenditure charges. So as we see, the administrative expenses of the office of CAG, including all salaries, allowances and pensions of the persons serving in that office, are charged upon the consolidated fund of India. So it's charged upon the Consolidated Fund of India. So these are the independent purpose. The tenure, his tenure is fixed, 6 or 65, and then criteria for removal, very stringent as a judge. Then eligibility for further appointments is not eligible for further office, and then entitlements cannot vary. Expenditure charged upon the consolidated fund. So thus they are not subject to the vote of the parliament. So this is how CAG's independence is maintained. According to Dr. B.R. Ambedkar, CAG is an important office under the Constitution of India and is one of the bulwarks of the democratic system of the government of India. So just bringing a concluding line from the words of B.R. Ambedkar. So this was about CAG, talking about introduction 148, uh, watchdog role, accounting role, auditing role, and then the independence provisions, and then a brief conclusion. This question is very important from the current context. Compare the discretionary power of governor of a state and that of president. This is always in news because of wrong reasons. Introduced by giving an account of the discretionary powers by meaning and types, enlist the discretionary powers of the president and the governor. So try to make some comparison because that is the question, core demand of the question, and then conclude based on the above point. So discretionary powers of the president and governor are those powers which they may exercise as per their own individual judgment. So as per their own individual judgment, without the aid and advice of the Council of Ministers. So whenever they exercise their power without the aid and advice of the Council of Ministers, as per their own independent judgment. So this is called discretionary power. So discretionary power can be of two types. One is the constitutional discretion and the situational discretion. So constitutional discretion are those which are mentioned in the Constitution, and the situational discretions are hidden discretion derived from the exigencies of prevailing political situation. So as and when time arises, based on the exigencies, this will continue situational discretion. So the president and the governor of states can act in their situational discretion in the following instances. So, one, when they have to appoint a prime minister or chief minister, we see every time when there is a new appointment after no party has a clear majority. So, you can recall certain episodes where there is no clear majority and how governor, in a partisan way, appoints his members from his own party. So appoint a prime minister. That's why it's called often called an agent of center. So appoint a prime minister, chief minister, after no party has a clear majority in the election when the incumbent dies in the office, and then dissolution of when they have to dissolve the Lok Sabha and state assembly when it has lost majority. So it's also a discretion when they've lost majority. Again, if you see, there's no majority in both the cases for appointment also for no for removal also, sending back the advice given by council of ministers for reconsideration. So I think you can do it only once, so you can send back the advice given by the council of ministers. There are some other cases where governor may act on his own discretion, such as establishment of the separate development boards. So these are some minor developmental aspects which come up, such as establishment of separate development board for Vidarbha, Marathwada, because they've been mentioned, Kutch, Saurashtra, Gujarat, with respect to administration of tribal areas in Assam, observance of law and order as long as internal disturbance on the Naga Hills continue. So these are some provisions where there's a discretion, but governor has a constitutional discretion in the following. So situational discretion, as we've seen, for both supplies, but coming to the governor specifically, has constitutional discretion in the following cases. The first is that he can reserve the bill for the consideration of president. So this is the first thing, he can reserve any bill for the president. Then recommending, and there are certain cases where it's obligatory also for such as if there's a endangerment of the position of high court, he must reserve. That is the constitutional thing, but that is not discretionary. So, reservation of the bill for consideration of president, he can do. Recommendation of the imposition of president's rule, again very controversial thing. He can do exercising his functions as the administrator of an adjoining union territory, always in conflict because as we've seen episodes from Delhi and Puducherry, that also we have to mention. Determining the amount payable to an autonomous district tribal district council and the states of Assam, Meghalaya, Tripura, and Mizoram, seeking information from the CM. So when he seeks information from the CM with regard to administrative and legislative matters of the state. So when he seeks information from the CM with regard to administrative and legislative matters of the state, Union Constitution grants discretionary powers to the governor under Article 163. So we mentioned the article also here that Constitution provides discretionary powers under Article 163, but it does not explicitly grant any discretion to the president. So this is the key thing, that there is no constitutional discretion directly given to the president, but it has been given to the governor, especially after the 42nd and 44th Amendment Act. The president is expressly required by the Article 74 of the Constitution to always. So this is a constraint with respect to president, that he has to always have a council of ministers to aid and advise in order aid and advise to, and to always act in accordance with the advice given to his functions. So that is the limitation on the president. It is only the situation discretion power which is available to both president and the governor. So this governor has more discretionary powers than that of the president. So that's why the office of governor is always in controversy, criticized as the agent of center, etc. So this is about the discretionary powers of president and governor. Next, as per the topic of constitutional comparison, we know that Indian Constitution is a synthesis of principle of British parliamentary sovereignty, as well as American principle of judicial supremacy. So, judicial supremacy in America and parliamentary sovereignty in the British. So as the three pillars L, E, J. So in one L is supreme, in one J is supreme. So this is the but our constitution is a synthesis of both. So briefly discuss the principle of British principle of parliamentary sovereignty and American principle of judicial supremacy. Discuss how Indian constitution reflects a proper synthesis. So there's a synthesis between the two and conclude accordingly. So the framers of Indian constitution gathered various features of the existing constitutions of the world, as we know. It's been ransacked from all the major constitutions and were modified to suit the existing conditions. So they were modified in a very blended way to suit the existing conditions, large size, and the needs of India. In this context, the prominent democratic models. So the prominent democratic models were, as we see, the first one, the British principle of because it ruled us for almost 200 years. So this was the first thing which you can look up. So British principle of parliamentary sovereignty, which implies that Parliament has absolute sovereignty and unlimited lawmaking powers. So Parliament is supreme in Britain, which can make law or unmake any kind of law by an ordinary process of legislation. Also, the courts cannot question or review the validity of legislation. So this is the British Constitution where the British Parliament is supreme. But now coming to the American thing, American principle of judicial supremacy, wherein no law of the land is beyond judicial scrutiny. So all the law made has to undergo certain kind of judicial scrutiny. The Supreme Court therefore enjoys an overwhelming power of judicial review to dismantle the legislation. So, Supreme Court in US enjoys an overwhelming power of the judicial review to dismantle an act of the legislature. So, this is about both the conditions. And now coming to India, India is reflects a synthesis of between the British principle of parliamentary sovereignty and American principle of judicial supremacy in the following ways. First, in the UK, we know that Parliament is supreme, but in India, it is not the Parliament but the Constitution which is supreme. Parliament's power is being restricted. Parliament enjoys limited, where if it is unlimited, here Parliament enjoys limited and restricted powers due to the written nature of Constitution. In Britain, there is unwritten Constitution, but here we have written Constitution. So this is designed by the following. For example, the Constitution is the supreme law of the land. So here, Constitution is supreme in India, not Parliament. Constitution is supreme law of the land, and all state organs, including the Parliament, judiciary, and executive, are bound by it. So, Constitution, you have to bow down to the Constitution, which is the supreme law of the land. The constitutional supremacy was explicitly echoed in the Keshavananda Bharati case and the Minerva Mills case. So these two form the basic structure of the constitution. So in India, there is a difference between a statutory law and a constitutional law. So both are different, and special provisions are incorporated in the constitution to make amendments as per Article 668. So we must differentiate between constitutional amendment law and the statutory law. So laws made by the Parliament are subject to the interpretations by the laws made by the Parliament, as we know, are subject to interpretations by the Supreme Court and High Court. So whatever law they make, it will fall under the scrutiny of Supreme Court and High Court. So judicial review sets in under Article 32, 13 to 26, as we see in the ideals of the object, in the light of ideals of the object of the Constitution. Also, there's basic structure doctrine apart from this to check. So the American, so this is about the Parliament thing, limiting about the Parliament. Now coming to the American constitutional scheme, follow judicial supremacy, but how? And provide for due process of law. But here, there's no due process. We have a procedure established by law, which we have taken from Japan. So the due process of law gives wide scope of Supreme Court to grant protection to the rights of the citizens, because it takes into account the reasoning, the legislative impact, and many such things. But in the procedure established by law, we're just looking at the procedure whether it's arbitrary or not. So it can declare laws violative of these rights void on the substantive as well as procedural ground. So this is how it can declare law void. While in India, the procedure established by law while in India, under the procedure established by law, the scope of judicial review power of the Supreme Court is narrower. So, because it is procedure established by law, it is comparatively narrower than that what exists in the US. However, the Supreme Court considerably widened. This is where comes the judgment of Maneka Gandhi. A Supreme Court considerably widened the scope of judicial review in India through its judgment in the Maneka Gandhi case of 1978 by accepting the concept of natural justice. So, as one of the essential components of the law. So here comes how judiciary is trying to widen its powers in India, thereby importing. the American concept of due process of law in a constitution. And also, we know that here judges are appointing themselves to the collegium system, which is not found there. Those things are also there, but just limiting to this aspect, just the Constitution of India has adopted a middle path between the British principle of parliamentary sovereignty and the American principle of judicial supremacy. While it is the prerogative of the parliament to amend the constitution and make laws, it is the duty. So, parliament's duty is what to make laws to amend the constitution, but it's the duty of the judiciary to decide the basic ideals and the structure of the constitution are transgressed by such laws. That is judicial review. So, judicial review is that parliament can make its law, amend the constitution, but judiciary will check on it. Judicial review as per the power given in constitution, as well as the basic structure doctrine, also which it has invented. So, this is about the synthesis which we're talking about between American and the British system in India. So moving on, it is not absolute separation of powers. So this is an important question at syllabus head. It is not absolute separation of powers, but system of checks and balances with regard to the three organs of the state that the Indian Constitution envisages. So this is a direct previous year question. So explain what do you understand by the absolute separation of powers, which is there in kind of US, and then explain how the Indian Constitution envisages a system of checks and balances with regard to the executive, legislative and judiciary instead of the strict separation of powers, and then conclude on the basis of the above point. So as we know that absolute separation of power implies that strict separation of absolute separation of power implies strict separation of power functions and personnel. So there is strict separation of power functions and personnel between the three organs of the state, that is the LEJ. So with respect to their power, with respect to their function, with respect to their functionaries. So there is a clear separation, this absolute separation of power. In India, separation of power has been laid down in the following constitutional provisions, such as Article 50. As you know, the DPSP, in which it states that the state shall have, a state shall take steps to separate judiciary from executive. So this is the key thing. But as we know that in tribunals and such things, there is a involvement of both the members. Article 50, which states that states shall take steps to separate judiciary from executive to ensure independence of judiciary. And also, this is one of the reasons where independence of judiciary was cited as a reason to strike down the NJAC verdict. And then, as per Article 122 and 212, so validity of the proceedings of the Parliament and state legislature respectively cannot be called into question by any court. So here, Parliament has been given that power that whatever proceedings it does in Parliament, it cannot be questioned in any court. Thus, providing it immunity in one sense. Of the members of from judicial intervention. So we saw about parliamentary privileges also, but this is immunity from the judiciary. And then we have 121 and 211. So where the judicial conduct. So this is with respect to judges. So judges conduct, judicial conduct of the judges of the Supreme Court and High Court respectively cannot be discussed. So this is the thing that they cannot be discussed. Judicial conduct, respectively, cannot be discussed in the Parliament and state legislature. So as per Article 361, as per 361, President and Governor are not answerable in any court for an exercise of their powers and functions. They've been given immunity once in violating even Article 14 also. So these are some articles where we can clearly see the aspect of separation of power. 50, which is DPSP, and then 121, with respect to judicial conduct, 122, with respect to parliamentary functioning proceedings, cannot be called upon in cannot be called into question in any court. And then 361, where president and governor, part of executive, are not answerable to any court for their exercise of official duties. Now, however, in India, come to the other part of the question, where, however, in India, the other three organs of the government carry out various functions. So, as we see that, however, in India, the three organs of the government carry out various functions, which would generally be considered, which would generally be considered within the purview of the other due to the overlap. So, this is the thing which we are seeing that. However, in India, three organs of the government carry out various functions which would generally be considered within the purview of the other due to function overlap. So there's overlap. So this also institutes a system of checks and balances to prevent the arbitrary use of power by one organ. So checks and balances is necessary so that one organ does not arbitrarily exercise its power. So this is reflected in the following ways. First, let us look at L and E. That is legislative and executive relations. So under this, the parliamentary system, in the Indian parliamentary system, as we see that the executive is also the member of legislature, right? They have to become a member of legislature, in fact, to become an executive in India. So the executive exercises legislatures law-making power under the delegated legislation, and also while passing ordinances under Article 123 and 213. So this is the role of executive, where they're doing both the roles. So executive exercising legislature law-making power, okay, under the delegated legislation, no, evident in the form of passing ordinances, etc. And then Article 75. So Article 75, it says that Council of Ministers shall be responsible to the lower house. So again, clearly mentioning that they are accountable to the lower house. And then coming to the next dimension, so this is about L and D, basic feature of the parliamentary system, where executive is accountable to the legislature. Coming to the legislature, judiciary. So legislature and judiciary, if you see, the legislature exercises judicial power, in case of breach of privileges, impeachment of president, and removal of judges. So this is a kind of judicial power where they're trying to exercise in case of privileges, in case of impeachment of even the president, because impeachment and such things, and then removal of judges. So they can even remove the judges. So it was tried last year. So Parliament, but no judge has been impeached till date. The Parliament has the power to enlarge its jurisdiction. So it can also enlarge the jurisdiction of the Supreme Court under Article 138. So this power is given to the Parliament to enlarge, and also the Parliament, the judiciary, if you see, use the tool of judicial review. Judicial review is the same thing. It's checking on the parliament on its laws under Article 13, 32, and 226 of the Constitution to ensure that laws made by the parliament and actions taken by the executive are constitutional. It is in coherence with the Constitution as per the basic structure is what it checks. And then coming to the executive and judiciary. So as we saw Article 50 directly, but tribunals. Now coming to the aspect which I was discussing, tribunals and other quasi judicial bodies are part of the executive, discharge in judicial functions. So that's why it's called quasi-judicial. So executive discharging judicial functions and mostly have members of the judiciary. So here executive is discharging judicial functions, and they also have members of from the judiciary. So this for the Supreme Court under Article 136, which is SLP of the Constitution, can grant special leave to appeal against the judgment or order passed by any court or tribunal. So even the tribunal's verdict also can be stayed. It can grant special leave to appeal against such verdicts of court or even tribunal. The power of appointing Supreme Court and High Court judges. So ultimately, who appoints the judges? It is the president himself under Article 124. So president appoints the judges. So judges are appointed by president with executive, and so on. So thus in India, separation of power has acquired its own uniqueness with sufficient checks and balances to ensure that no organ of the state exercises arbitrary power. So ultimately, this is done so that arbitrary power is curbed. No organ should have such an arbitrary power. So often it's cited that judiciary has too much power because it's appointing itself. But overall, if you see, there's no checks and balances working coherently. So executive and legislature and judiciary, executive and judicial, those three dimensions we must always remember. So in continuation with the earlier question, so this is of the same line of thought where there is checks and balances. So here the dimension is with respect to L and E. So the legislature in the parliamentary system ensures executive accountability at various stages. So as we see, legislature in the parliamentary system ensures accountability, executive accountability at various stages. Discussed in the context of India, discuss in the context of India. So, as we know that in the parliamentary system of government, the political party command majority in the legislature which form the government, and the legislature ensures continuous executive accountability at various stages. Be it when they talk about stages, it is policy making, it is implementation of the law or policy, and also during the post implementation of the stage. So, policy making, policy implementation, and also post implementation stage. So in India, there are various devices and opportunities available to legislature to ensure executive accountability. The first being the deliberation and discussion role, which is today no not very much functional, as we have seen in the recent budget session, where without discussion many bills were passed, and also Chief Justice lamented on this. So the parliamentary control over the ministry rests on the premise that any action of the minister can be called into question by any member. So this is the key thing, that any action of the ministry can be called into question by any member, and the minister responsible for the administration of the ministry has to defend the acts of his officials and take the blame for lapses. So this is how the directly through discussions, he has to acknowledge and come out and speak in public. So this is done through various methods, such as first is the debates. So debates, members debate on the discussion of the policy direction, the manner of policy implementation by the executive. Now debates are now not taking place. And then question hour. Question hour is considered the most effective tool. So question hour is considered the most effective tool. Through this, the MPs hold the government accountable. So MPs hold the government accountable by posing questions to ministers during the question hour, initiating the debates or calling attention to ministers to important issues. So this is how, talking about the question hour also. It's the most, but recently question hour was dropped. That is also one more thing. So debate is not happening. Question hour is not happening. And then other instrument is such as zero hour, where the members are free to raise any matter they think are important, but no, it's also largely ineffective. Half an hour discussion on the matters of public importance. There is frequent adjournment on the motion. Some instruments to hold the exit. So in terms of other instrument, we have zero hour. Apart from question hour, which is major, we have zero hour, half an hour discussion, adjournment motion, etc. And coming to motion of thanks, the debate of the motion of thanks, the debate on the president's address to the parliament is another opportunity to discuss the government's performance or voice any concern by the way of amending the motion. So here, amending the motion amounts to defeat of the government. Then comes parliamentary committee. So within the parliamentary system, there is backdoor working of parliamentary committee, various committees, such as the Public Accounts Committee, scrutinize the work of the government department and recommend suitable action in case of lapses. Again, Public Accounts Committee role was directly asked, and there's approval of the and ratification of laws. Parliamentary control is also exercised through power of ratifying the laws. That is, if the government has majority in Lok Sabha but not in Rajya Sabha, the government will be forced to make substantial concessions to gain the approval of both the houses. So this is where the other house also kicks in. Now this is about the first part, and then moving on to the financial control. The financial resources to implement the programs of the government are granted to the budget. Again, here the Lok Sabha Supreme, the preparation and presentation of which is constitutional obligation of the government. This obligation allows the legislature to exercise control over the purse, that is especially Lok Sabha, uh, uh, control over the purse strings of the government and control the policy of the government. The legislature at this stage can pass various cut motions. So here comes another in the process of financial thing: cut motions, policy cut, token cut, economic cut, to raise the concerns about the policies. So through such motions, cut motion, policy cut, token cut, economic cut, they can raise concerns about the policies of the government that are reflected in the budget. And then coming to no confidence motion, so this is a key thing which only can be used in Lok Sabha. No confidence motion is the most powerful weapon that enables the parliament to ensure executive accountability. Ultimately, it's a last resort, we can say. However, it must be noted that after 1989, several governments have been forced to resign due to lack of confidence, mainly because of coalition politics. Thus, the parliament can be effectively control the executive and ensure more responsive government. So, as we have discussed, it starts from basic, from the debate, deliberation, the question hour. From those aspects, it starts debate, deliberation, question hour, zero hour, adjournment motion, half an hour discussion, then motion of thanks, then going to parliamentary committees, then for the ratification of laws, Lok Sabha, Rajya Sabha, then financial control specifically, um, and then though confidence motion ultimately last resort. So, however, parliamentary control in India is considered not effective. So, this is the thing, because not effective due to various reasons. So, this becomes a crucial dimension in the current context. Various reasons such as lack of time and expertise of the parliament. So, as we're seeing, disruptions has become a norm. Ex post facto nature. So, there is ex post facto nature of control, that is after things have passed. For example, the Public Account Committee, we can give disruptions. The current context is not effective. Is the dimension. So as we're seeing, the disruptions leading to loss of time and also precious taxpayers' money and majority support enjoyed by the executive in the parliament. So this is the thing, reducing the possibility of effective criticism. So nonetheless, the possibility of the executive being ultimately subject to parliamentary scrutiny, even if it's ex post facto, act as a formidable tool to ensure executive accountability. Further, the parliamentary control can be strengthened. How they can be strengthened, these are some passing remarks which we can give: that when we make use of parliamentary committee systems effectively, when we strengthen the deliberative democracy, so then also, as we saw in the first part, debate discussion, if they happen effectively, if debate discussion deliberation happens effectively, question hour, and then zero hour, all these things happen effectively, then also we can ensure executive accountability. we can pass in the concluding remarks.